much. Good morning and welcome to the 8th meeting of the Constitution Europe External Affairs and Culture Committee in 2025. Our only agenda item this morning is to take evidence as part of our inquiry to feed into the consultation for the UK Government's review of the UK Internal Market Act 2020. Before I introduce the witnesses, I wish to state that there is an active court case, Biffa Waste Services Limited against Scottish ministers, which is relevant to the committee's current inquiry. Given that this case is currently active, we have sought the presiding officer's permission to be able to refer to the deposit return scheme exclusion process today. The presiding officer has permitted discussion of the policy issues so as to enable scrutiny while avoiding direct comment on the specifics of the active case. Any reference by committee members and witnesses should be within these parameters, and direct discussion of the active court case is to be avoided. So we'll be hearing from two panels this morning. Our first panel, we have Professor Thomas Horsley, Professor of Law from the University of Liverpool, Professor Joe Hunt, Professor in Law from Cardiff University, and Dr. Corey Brown-Swan, Lecturer in British Politics, University of Stirling. And joining us online, we have Professor Eileen McHarg, Professor of Public Law and Human Rights from Durham University, and a warm welcome to you all. Can I start with a couple of questions, and I'll bring in other members. But the committee has previously recognised that there is a significant challenge in managing the tensions which exist in any internal market between open trade and regulatory divergence. What opportunity does the review of UKEMA provide to address this tension? And I'll maybe go to Dr. Corey Brown-Swan. Thank you.
Thank you. Thank you so much for having me. I've worked alongside Thomas and Nicola McEwen, as well as Lisa Claire Whitten, on a review of the UK Internal Market Act, which was published last year. And to be perfectly frank, we didn't expect to see significant movement on the idea of revisiting or reopening the terms or parameters of the Internal Market Act so quickly. So I think we should welcome that as an opportunity. Obviously, there's a range of options going from maintaining the status quo, which looks unlikely, to a repeal and reform, which also looks unlikely. But I think we should take this opportunity to think about how, within the parameters, every internal market needs some sort of umbrella legislation to allow trade to happen. But how can we ensure that that is consistent with devolved powers? I think there's probably two main aspects. I think the first is focused on more legislative aspects, addressing the way that the market access principles work and ensuring that if there's an policy area of legitimate public interest, that devolved parliaments should be able to use their devolved powers to legislate in those. The other is procedural, and that's where we've really seen the UK Internal Market Act come into difficulties thus far, because of the challenges around the exclusion process, both in transparency and the opacity of the process, but also the balance of power by which it's negotiated, which is really unique to the UK internal market. When we look at Australia, when we look at the EU, other internal markets which do have their tensions, we don't see that concentration or centralization of power.
Thank you. Professor Hunt.
Yeah, I feel we'll probably be echoing each other throughout this session, in that these are issues that were raised at the time that the legislation was created. They were flagged then that the EU framework that was being replaced, that we weren't seeing continuity with how that worked. We also were looking sort of out of step with what we were seeing across other sort of decentralized or multi-level states, and how they manage. Of course, there's very many different experiences in coming to manage a market, but as we pointed out, that balance between respect for local democratic choices and the integrity of the market, that every state, every multi-level system will have to find its own balance and what it values within that. And of course, this piece of legislation, the Internal Market Act, very much put its centre of gravity on the integrity of the market, free movement, in a way that was a break with what we'd seen before and what we see in other sort of multi-level systems. And so to the extent that this review gives us an opportunity to revisit some of those issues that were live then and continue to be live. So it's about, as Corey has flagged, looking at that mutual recognition principle that has become sort of, in this legislation, a very absolute rule that affords very little scope for autonomy and local decision-making to exist unaffected. And it's how we sort of build in the opportunity for that to be given more space within the legislation. So whether that is through an expanded set of justifications, writing those into the legislation, greater respect for subsidiarity, whether there's an opportunity to carry that over in some way, that those are the sorts of issues that I think we've all been saying for some time that the legislation has been missing.
Professor Horsley?
Thank you very much again to echo the comments of my fellow witnesses. Thank you for the invitation to contribute. I agree with much of what has already been said. I'll perhaps just stress a few issues at the opening. I think there is a functional problem, so we should always keep that in mind here. So the UKEMA itself and the related common frameworks, we're not tilting at windmills here. There is a functional problem that has arisen following the UK's exit from the European Union. The scaffolding of EU law has been removed, and we do have a situation now where it is necessary to manage the coexistence of devolved competences within the UK Constitution. I think the review is an opportunity to revisit, and there are different options, which I'm sure we'll get into in greater detail. There's different sliding scales of ambition and some low-hanging fruit and some more ambitious plans. But it's an opportunity to revisit, basically, I would say, three key imbalances in the current UKEMA framework. The first is that the UKEMA framework itself is, it's not consensual. It was imposed on the devolved institutions. And I think it's fair to say that a stable legal framework, if that's the option for managing diversity, should be based on co-design and consensus. And that is, if we look at internal market structures around the world, that's a sort of, a starting point. So there's perhaps an opportunity to manage that. The second, and I'm echoing comments of my panelists here, is that it's an opportunity to revisit the balance that the UKEMA strikes between local regulatory diversity and uniformity or cross-border trade. In comparison to the EU internal market, the UKEMA is very highly deregulatory by default. And as my fellow witnesses have already alluded to, there is some scope, I think, to expand the justifications and perhaps rebalance some of the UKEMA market access principles. Finally, I think one of the real significant flaws, in my view, for the UKEMA as it stands is it's highly asymmetrical. So we have a system where one of the constituent players, the UK government, has this kind of dual role. It regulates for England, but it also has this sort of central function as the gatekeeper, if you like. And effectively, as we've seen, and again, I'm sure we'll get into the detail of this this morning, effectively we have a situation where the UK government can be a veto player. It can have a veto over the policy choices made here in the Scottish Parliament. And I think the review is an opportunity to revisit those three issues. Thank you.
Thank you. Professor McCarg?
Thank you. Thanks for letting me join online. I mean, I agree with much of what has been said already, and I think you're going to find a lot of agreement between us this morning. Just one point to emphasise, the consequence of that imbalance in the Act itself in favour of market access rather than regulated divergence is that the process of balancing those two objectives has been pushed to the political process. It's been pushed to the exclusions process. And that is a discretionary process. It's one in which, as Thomas has said, there is an imbalance between the roles of the UK government and the devolved government. And it's one which has imported a very high degree of uncertainty into the operation of the market access principle. So because of this opportunity to make exclusions, the legislation itself is not the whole story. How it operates in its broader political context is really, really important. So as I said in my written evidence, for me, although there are several ways in which you can try and address these problems, Thomas referred to low-hanging fruit and more ambitious reforms. For me, a satisfactory solution to the problems that Ukima poses is one which seeks to reduce the reliance on political discretion, to strike that poor balance between market access and regulatory divergence.
Okay, thank you. In a report on the UK Internal Market Act that was published in 2022, the committee was of the view that it would be regrettable if one of the consequences of leaving the EU was any dilution in regulatory autonomy and opportunities for policy innovation. Professor Horsley, you've already touched on that. Could you expand on what your view is regarding that policy dilution and lack of possibility of innovation?
Yes, I mean, I think it is worth recalling that during the membership, the UK's membership of the EU, of course, devolved powers were exercised subject to the compliance with EU internal market norms. But they, of course, applied equally across the UK, so that there were restrictions. They bited, the bite there was different to it is under the UKIMA now. But with that scaffolding removed, we do have this opportunity for sort of divergence and dilution. And I think we see that in two ways. And again, we can speak to some practical examples, both here in Scotland, but in Wales, if necessary. But we see it in two ways. So the market access principles embedded in the Act, the impact on the capacity here of the Scottish Parliament to legislate and to or apply its legislation to incoming goods and services. They're hard limits. You need to, as Aileen mentioned, you need to seek an exclusion, which requires consent essentially on the part of the UK government. So that dilutes, knowing that you have to go through that process and that your policy choices are subject to this veto power, of course, has a diluting or chilling effect. Also, we see the navigation of this, the market access principles, nudging the Scottish Government to work in a more intergovernmental space. And of course, if you're making policy choices, either bilaterally with the UK in the common frameworks, or through the exclusion processes, or multilaterally with the Welsh Government, for example, as well, then inevitably you're going to be reaching compromise. You're going to find your choices on depth of policy, but also the timing of the introduction of those policies diluted. So I think, we've got examples on single-use plastics in Wales, we've got examples of the deposit return scheme, we've got examples around glue traps. All of these I've discussed in the evidence and also in the report that I co-authored with Curry and others. So I think we do have some pretty concrete examples of the ways in which this is affecting regulatory autonomy and also policy ambition here in Scotland.
Thank you. Does anyone want to add to that at all?
From a Wales perspective, Thomas, you alluded to single-use plastics. We're currently looking at the DRS again in Wales, and one of the things that perhaps we're seeing is, as we mentioned, that chilling effect, that the policy innovation is being frustrated through the concerns about the impact of the legislation. And so perhaps sort of in the shadow of the legislation, the four nations are pushed to cooperate. But again, that then sort of leads perhaps to lowest common denominator type arrangements. And so with something like the DRS, Wales has stated it wants to go further because it is in a position where it's already gone further on recycling. It's in a different position than some other parts of the UK. And so it's ready to go further on that. And so the frustrations of working on a four nations basis, how that might bring sort of lowest common denominator solutions, are very real as well.
Just in what you've been saying about the dynamics and the Scottish Government having to work at that intergovernmental level, has there been any examples of cross-cooperation between the other devolved, with the Zenith or with the Northern Irish Assembly, with the governments coming together in a sort of united front, if maybe against the UK.
I mean, there are some. This happened under the previous UK administration, and I expect it to continue, particularly the narrative of resetting relations. But some examples: we've had joint consultations, which we can, I think, all agree form the early stage of a policy cycle on wet wipes, the banning of wet wipes containing plastics, tobacco and vapes, that perhaps got the furthest. You know, there's been cooperation around horticultural peat. There's quite a lot of that's a kind of positive side, if you like. There is cooperation, but I would stress, and I say this in my evidence as well, that has impacts on the scope of policy ambition for the Scottish Government, as we've heard, but it also has a very important impact on political processes. It's executive empowerment. We're having policy making and policy decisions taken in the intergovernmental space, which requires us to think carefully about the impact on devolved legislative processes. And I think, as I say in my evidence for the committee, is to continue to consider the impact of that on the Scottish Parliament's ability to scrutinise policy and also to shape policy substantively.
Thank you. Yes?
Sure.
Sorry.
I would echo Thomas's remarks. I'd like to offer a bit of a comparative example as well. I think one of the fundamental problems with the Internal Market Act as it currently stands is it treats regulatory divergence as something to be avoided almost at all costs, at the expense of the quality and tenor of intergovernmental relations, at the expense of policy making and devolved competencies. And I guess what I would like to encourage people to think about is regulatory divergence can be a feature rather than a flaw. When we look at the introduction of deposit return schemes in Australia and Denmark, so within the Australian internal market and the EU single market, we see difficulties in introducing schemes which do restrict the flow of trade. But ultimately, those schemes have become models for others and have really pushed forward and led the way on environmental protection. There's tensions, there's difficulties, there's often quite a lot of mobilization from industries who are concerned about how this affects them. But ultimately, we see industry adaptation and we see the expansion. Now, Southern Australia and Denmark lead their kind of internal markets in recycling rates, in return rates. So we can see this as an opportunity for policy innovation, and I think the threat of regulatory chill is really profound.
Okay, thank you very much. I'm going to move to questions from the committee. I'll bring in Alexander first.
Thank you, Convener. Can I maybe touch on the sort of the reprioritising of the common frameworks as we move forward, because there is an understanding that the UK government would now appear to be prioritising the common frameworks as the sort of main focus for the four governments to discuss and collaborate on the new policy areas that they may wish to cover in going forward. So it would be good to get a flavour of how realistic that is in bringing all that together to create the new frameworks that are being potentially looked at or discussed. I don't know who wants to, maybe Dr. Corrie-Swan, you want to maybe come in first?
Sure. I think that was perhaps a bit surprising in the kind of announcement of the review, this idea that the common frameworks, because when we look back to the origins of the internal market, there was this emphasis on common frameworks. Common frameworks were to provide that solution. Yep. So we seem to be going back to a perhaps older solution. I think common frameworks remain important, but as Thomas said earlier, there are issues around transparency about how those intergovernmental processes will take place. I'm happy to hand over to my colleagues who are much more expert on common frameworks than I am.
Shall I say something?
You can add well.
Okay.
Thomas, you want to maybe come in first?
If I may as well, I'm conscious also that Aileen's around, so please, I'll be brief on this. I would say, yes, I say this, I set this out in my written evidence in full, so I'll just be very brief. The reprioritisation, I think, addresses at least one of those primary concerns. The advantage of the common frameworks over UKEMA is that they're consensual and co-designed. Yeah. So that's very important. So there's a good platform there. I think they need work in order to function. I think one of the things that's interesting, and I'm picking up on Aileen's remarks here, is the common frameworks they're very light on substantive detail. Okay. So the UKIMA is very clear about the market access principles, but how do we manage divergence in the common framework space? It's kind of left to politics and on a case-by-case basis. So I think there's some challenge in fixing them. Obviously, there's the issue of taking policy making into the other intergovernmental space, which I've mentioned. But one final issue is, I think, to be alert, and I think the committee should be alert to this, is that yes, if the common frameworks are prioritised, there are advantages. But if the UKIMA is still in the background, the legal framework will still bite. And you're relying on the present UK government making a political commitment to operate through the common frameworks. That may change. And if the UKIMA remains in its current or fundamentally unamended form, then it's in the background. And it remains a very potent challenge to devolution for the reasons we've discussed already this morning.
And if that was going to change, if they decided they were going to manage that whole process instead of having it in the background, or it was a different process, how would that affect where we were going if there was a divergence on that process?
Do you mean if there was are we talking about changes to the UKIMA?
Yes, if the UKIMA changed.
I think a good landing space, assuming that the UK government doesn't move on its ambition not to repeal, I think a good landing space would be is to sort of work in the space of the common framework, subject to some issues I've raised, addressing those, but making some changes to the UKIMA framework, I think, at a minimum, in order to ensure that if the levers are pulled, there is still sufficient space for the devolved institutions to defend their policy preferences relatively, or in a way that they can't do now.
Yeah, I think, reflects we say, it's not a panacea that we are sort of reverting to intergovernmental interaction that is perhaps operating more positively at the moment than it has for some time in this space, and yet, you know, it would be useful to have some sort of guarantees underpinning how that moves forward. I think one of the things that could very usefully be done to connect to things that we've already been discussing is in relation to that exclusions process. Yeah. And because what we've been finding after the legislation was introduced very quickly, working out the various sort of implications of that, the procedural implications, how does that connect to common frameworks? As we've highlighted, the frameworks themselves very different across different policy areas in how they engage with the idea of regulatory divergence. Some of them, this seems to be okay, you know, and it's finding a space for that, whereas other frameworks are more about how we move forward together in those. So they take different approaches depending on policy sector, depending on particular issues being addressed. But if we do reach a point where there is agreement to diverge, how then that connects with the legislation, how that exclusion process then operates, and that throws you back as it's operated at the moment, highly problematically. Yeah. And so we want, as much as possible, to see built into the system clear processes, clear timelines, and understandings about what is possible within that exclusions process.
And Professor Ayling, do you want to add anything?
Yes, thanks. I actually wanted to make a quick comment on the last question as well, if I may do that first. So on the question about the dilution of regulatory autonomy, I just wanted to point out that although that one way in which that can be diluted is through the push for cooperation, it can also come about through unilateral action. And that's the best example of that is the gene editing legislation adopted by the UK Parliament for England, which had implications for the ability of Scotland and Wales to effectively maintain a different approach to gene edited products. In relation to common frameworks, absolutely agree that the key issue here is how agreements reached under the common frameworks then translate into UKIMA exclusions. Of course, that is what the exclusion process was put into the legislation to facilitate, but it remains discretionary. So there is no kind of obligation to turn a common framework agreement into a UKIMA exclusion. So that would need to be looked at. The other problematic aspect of the common frameworks process is what we've alluded to earlier about the fact that these are intergovernmental processes which can be very untransparent, which cause problems for legislative scrutiny, which cause problems for stakeholder involvement and so on. So I think an improved common framework process would want to address those issues of stakeholder participation and democratic scrutiny as well. Thank you.
Thank you.
You all share the same paradigm, don't you? I mean, you've all worked together. You're all pretty much on the same page. Is that a fair comment? You all know each other? You all work together?
I'm sure you all work together and know each other as well.
Yeah, but do you have any disagreements with each other? Do you
Yes, I would
So
say.
what would your difference of opinion be with your colleagues in relation to UKIMA then? What's the point that you would make that is distinctive to your evidence?
I'm probably more sympathetic than many to the idea of having a legal framework underpinning the regulatory system. So,
Right.
you know, UKIMA as itself, I've said before, we're not tilting at windmills. There is a functional problem. Law is a solution to doing this. Many of our internal market systems rely on the application of the market access principles, judicial enforcement. You know, I think that the issue here is the primary issue is dealing with the balance between regulatory diversity and uniformity. I think we've got a system which I think, in comparative perspective, is highly deregulatory, and I'm not sure that it's necessarily optimal. I think there's reasonable space for that to be adjusted. Doesn't necessarily mean abandoning the frameworks or abandoning the UKIMA. I'm perfectly comfortable with
So,
that.
Professor, your take is that we do need something like UKIMA, but it needs to be amended to bring define process to the fore.
I'm not fundamentally against the idea of having a legal framework, a legal underpinning to the
single market,
to the operation of the single market.
Yeah.
I think it's all about calibration.
Yeah.
And there is, of course, another layer which I don't think will be addressed. So, challenge is how do you manage the duality of the UK government's role? I think that is a challenge, but that's not a challenge that's unique to UKIMA. That's something that's the nature of our very constitutional.
That's a constitutional issue.
Yeah,
yes, understand that point of view. What's your point of difference with your colleagues, Professor Hunt?
Yeah, I was and perhaps remain less convinced that the horizontal legislation that UKIMA provides a horizontal rule
Yeah.
that is necessary.
You don't think UKIMA is necessary?
I think there could have been other ways to manage the market issues.
Talk about that, if you would. What are the other ways?
So we have UKIMA acting as a backstop,
As a legal framework?
as a legal backstop with a very strong mutual recognition, absolute mutual
Yeah.
recognition
Yes.
role, with the idea that this is in some way protecting devolution because it doesn't stop the devolved legislatures from adopting laws, but in fact it hollows out the effects that those laws can have if they cannot enforce them against imports that come in from, they can come in externally. As long as they've gone to another part of the UK first, they can come into Scotland, Wales, and into England, Northern Ireland. So we have that hard backstop of the legislation, but the shadow that casts, with it being in such absolute terms, has such potential for a chilling effect on what can be done.
How is trying to protect the playing field in terms of market, the freedom of the market? How is that a chilling effect? I cannot. Several of you have used this term. How is that a chilling effect compared with what we had when we were members of the European Union, when we were in receipt of 12,000 different directives and regulations every year, none of which were given proper democratic scrutiny? So how is that a chilling? I don't follow.
So we have the situation where previously within the EU, there was scope for harmonisation, for legislation to be made in common and together through the processes within the EU institutions, but equally there was space there for local divergence. And that could happen
Within a
at
tolerance. Within a tolerance.
Within a tolerance.
Yeah, as there is in the current setup here, no?
Not within the same tolerances by any means.
What?
Because we've raised already the issues of the exceptions and the exclusions and how very, very limited they are in this legislation. What wasn't read over from the EU legislation were the range of justifications that are available to the local regulator to protect their regulatory choices. And they include protection of the environment, protection of the consumer, a whole host of issues that haven't been read into this piece of legislation. So there will have been use made by the UK, by Scotland, by Wales.
These are
of
nuances.
those justifications.
These are nuances, though, aren't they? In the context of what Professor Horsley says, he fundamentally leans towards having this legal framework. You're saying there's another alternative, which would create scope for nuances, but I'm not sure I understand what...
But what we already have, of course, is the fact that within the devolution settlement, within the legislation, within the Scotland Act, within the Wales Act, there are large areas that are reserved.
Yes.
Areas relating to economic activity in relation to the
Yes,
management.
because we're living in a
of
devolved setup.
Yes,
Yeah.
so there are things that were chosen to be reserved.
Yes.
We're now talking about those areas which have been devolved.
Yes.
And so within those, how deep should the reach be to limit what choices can be made? Because ultimately, we're leading to the progression is an argument that's saying, well, reserve everything, because then everything...
Well, not really, because what we had under the European Union was the legal underpinnings of the single market. Some people say it was the greatest achievement of the European Union.
Okay.
And all UKIMA sets out to do, and the review obviously is going to look at how well it does it, is to do the same. No?
No.
Why no?
Okay,
I mean, it's all about the internal market. It's all about the ability of a Scottish business to make a product and be able to sell it throughout the United Kingdom without any barriers. That's exactly, in large measure, what the legal underpinning of the single market in the EU was, that we had to apply, that we had to comply with. And as it was adjusted and changed every year, there was, I mean, you talk about democratic scrutiny and intergovernmental space, I mean, and transparency, there was very little transparency in relation to the EU. So you said no, and I interrupted. So please tell me why you say no.
So, I mean, in terms of overriding objectives, in terms of facilitating free movement,
Yeah.
then there is a common objective there. But in terms of building in respect for local choices,
Yeah.
that the EU system provided more opportunity for that than this current system.
But at the end of the day, in the European Union, ultimately, the centre of power was the European Union's institutions, the Parliament, the Commission. We had the same situation there. In fact, we had less ability, probably, given the scale of the regulation that came the direction of the United Kingdom as a member. We had less scope to do all this co-designing and consensus working. I think that's the reality. That's the reality that most business people would probably, I would have imagined, take. We don't have a voice of business in this evidence session, obviously. But you disagree.
I think that the piece of legislation that we have does not afford the same scope for local choices to be able to effectively operate as we had under the previous EU system.
And
because
You've brought in a lot of different questions
Yeah,
now,
I
and I'm
haven't got
conscious
to the
that
other
we
two.
have the other witnesses might want to
Yeah,
contribute. So I'm going to let them come back in, and if there's time, we'll come back to you.
Oh,
Okay.
am I finished? I didn't hear the points of difference.
No,
in
I
the
want
two.
I want the opportunity for the panel to respond to the many issues that you've raised.
All right, okay, exactly.
Okay,
Right.
thank you.
Okay, yes.
Great.
I misunderstood.
Thank you. I think I'm coming at this from a political science perspective, and you'll know from the work I've done with this committee on intergovernmental relations that I do probably have a more faith perhaps in the intergovernmental process that reasonable people sitting in a room
Yeah.
together can come to conclusion
Yeah.
and can make an agreement. I think referring to your question about how is this any different from the EU or perhaps looking at other internal markets, Joe's point on the fact that if there's a legitimate public interest in public health or the environment, this is the same in Australia. We look at the Australian internal market, which was in many ways cited as a model for the UK internal market, and we did not see those provisions built in. I think the argument that Brexit was to offer more power, to offer this Parliament more power, has very much been challenged. The Scottish Parliament passed legislation on glue traps, the ban on the sale and use, only essentially to be curtailed by a Secretary of State. I appreciate that's a relatively minor policy area where we say, oh, well, maybe it doesn't have that many consequences. But I think I'm really uncomfortable with this Parliament's power being constrained in that way. We have a devolution settlement which sets out the powers and the policy areas in which this Parliament should be able to legislate. Obviously, it legislates within the broader context of an internal market.
Yes.
But why should you be giving up your powers in this way? And particularly when we look at the market impact of some of these policy areas.
I suppose it all comes down to your comment about reasonable people getting together and working through things in a process that creates proper intergovernmental relations, upon which I think we might agree. Professor McHarg, how does your take on this differ uniquely from your colleagues?
Well, I have worked with Joe on this topic right from the point at which the bill was being proposed. And nevertheless, I think I have a much more sceptical view of intergovernmental processes than she does. As I said earlier, my view on this would be eliminate or reduce political discretion as far as possible. One of the consequences of the difference, the different content of EU law that she talked about, and you described it as a nuance, but nuance matters and context matters. The consequence of that difference that you could balance on a case-by-case basis, the value of free trade versus the value of environmental protection or protection for public health or whatever the public interest objective was, that there was an opportunity to ultimately test those balances in court. And we saw that being tested, for instance, in relation to the minimum unit price for alcohol. So that would be one difference for me. I share Thomas's preference, I think, for more legal regulation here and less reliance on intergovernmental processes. My other concern in all of this is about how this affects your role as legislators, how the UK Internal Market Act intersects with devolved competence. And it's not just that the content of the restrictions that UKIMA places on your powers are different compared to the previous EU law constraint. It's also the way in which they intersect with devolved competence, the processes surrounding enforcement of UKIMA. And I think those are very problematic in terms of uncertainty. So at the point at which you were legislating previously, this Parliament was bound by a hard limit. It could not legislate contrary to EU law. That was something that had to be addressed by the minister. It was when introducing a bill, it's something that had to be addressed by the presiding officer. There are procedures for making references to courts. None of that applies to UKIMA because technically it has no effect on the validity of devolved legislation. But what it does do is potentially severely affect the effectiveness of that legislation in practice. So I think all of those things really matter as well.
So you're calling for a stronger, you're agreeing with Professor Horsley that there should be a stronger, leaning towards a stronger legal framework then, are you? You don't have any
So
faith in intergovernmental working, and yet the argument you made was an argument for intergovernmental working, the way that you described it, where governments on this island, because we are relatively, geographically speaking, living on a small island, that we all work together in order to accommodate each other and to agree as much common space as possible in policy terms between us.
I don't think I made that argument.
Because you don't have any faith in intergovernmental relations.
I said I have less faith in that as an alternative to proper legal processes.
So you want a stronger legal framework. Am I right in picking that up?
Intergovernmental processes take place in a legal context. The legal backstop is as important as the intergovernmental processes. If the legal backstop is out of line with the intergovernmental processes, you are going to come up against problems, for instance, where the intergovernmental process breaks down and you're forced back on reliance on the legal rules. So for me, it's important to get the legal rules right. And not just suggest that as long as we can all agree, then that's all fine, because it won't necessarily always
you
be
can
fine.
you can have intergovernmental working with
I'm going to have to move on to other
Can I make one
members.
last point? Which is, you can have all
very
of that
quickly.
if you have a mediation and a process of resolving difficulties that arise that everyone buys into at the outset. Your point of view, it's very interesting, because your point of view, Professor McCarthy, is completely at odds now with Dr. Corey Brown-Swan's, and that is very interesting to hear.
I think we'll move on to questions from Mr Brown.
Thanks, Convener. I think that last point, interestingly, is the direct opposite of what Mr Kerr started by saying, that there was unanimity and consensus amongst the four. I just wonder, though, if you look at the reasons for UKIMA, which in my view, and I'm speaking as a politician, I realise that you guys are not, was just sheer political vindictiveness and a power grab. It was reverse engineering of devolution. And if you don't believe that, you've got to look for the rationale that was there. Just think of the contributions. The asymmetry, you know, it's hard to believe there are people in this parliament that are happy that England is set above the rest of the UK in the way that it is, and the example that was given with gene editing, I think it was. But the fact that the UK can legislate for England without needing to get any other exemptions, or you'd think that would trouble people in this parliament, but it doesn't trouble all of us, which is unfortunate. Or the fact that the internal market is actually sets itself against classical market theory. It depresses ambition and aspiration and innovation. It's designed to do, well, that's the effect it's having. You've mentioned the chilling effect. So there's no rationale for what's being done here. It's a power grab. In the same way as at the point of Brexit, the monies which came to Scotland from the EU were taken back by the UK and have disappeared ever since. If that is the case, and I realise that's my point of view, and it's interesting to see Brexiteers trying to wrestle with the contradictions of what they've created. What would be the? I realise that repeal seems to be off the cards, because the UK government likes having that power over Scotland. They didn't have before, and the new UK government has gone back on the Welsh and Scottish Labour position of advocating repeal. But just for the exercise in our heads, if there was to be repeal, I think we've had some indications of what might replace it, a stronger legal framework. How would you envisage the better working of the so-called internal market within the UK? What would be the architecture if we were to do away with UKIMA? Is it just about building up legal structures that would serve the same purpose? If I go to Professor Horsley first.
Yes, I think I agree, and I said this at the outset, that we do need a framework, and as I've said before, I'm less uncomfortable perhaps with the idea of having a legal framework. I think UKIMA, the landing space that I would prefer, would be a reformed UKIMA. And I think what I'm about to say perhaps answers the previous committee members' concerns. I think one of the key issues for me in the way that the current system operates, there are things we can't fix. The asymmetry, for example, is embedded in our constitution. But one of the things that strikes me in comparative perspective as being very, very strange is the fact that the devolved governments under UKIMA have to ask for permission. It's a permissions-based system. You want to legislate, you have to actually ask, effectively, in this UKIMA space, you have to ask the UK government for permission to do so. And I think that it's strange. That veto-playing role is the reverse of the burden that we saw in the EU context. So this is a direct point of difference to the EU legal system. In the EU legal system, the Scottish Parliament could legislate, but the burden of proof would then be on the centre. It would be on the European institutions, the Commission, for example, to raise a case. You didn't have to ask the Commission for permission to legislate in the first place. So I think reversing the burden of proof, as I set out my evidence, is something that I think that could be integrated into a reformed UKIMA structure alongside the other things. And I'll give you one example. Glue traps. You know, we have a situation where what I can see, a very thin evidence base. There was a great song and dance made around creating or not creating that as an exclusion. So I think, you know, I would expect, or my ideal view would be that the burden of proof would be on the UK government in the first instance to adduce sufficient evidence that that particular point of divergence would create the obstacles to trade that the businesses you reference can see as concerning. And then the burden, if they can show significant impact, then it falls to the Scottish Government here and the Parliament to make that application for an exclusion. So I think reversing the burden of proof around exclusions to me seems entirely rational and logical. It's in line with principles that we see in other systems. And I think that's something that is really key, and that's something that can be reformed in that context. And yes, so I think that alongside some of the low-hanging fruit, that would perhaps be my most ambitious wish if we were to maintain the legal framework.
Is there a view on structures different to that outlined by Professor Horsley? Professor Hunt?
I think reflecting, when you talk about the rationale, if we go back to that at the start, I mean, you know, this was a piece of legislation adopted at pace. I think if we go back to when this was taking place, this was at a point at which it looked as though the UK would be could be falling out of the EU structures. It would be moving to a position where it would be making its own international trade deals for the first time with a devolved setup in place. And so having this piece of legislation at least guarantee to external partners that they could trade with the UK in the knowledge that products would have free movement within the UK. So I think that was a very strong driver as well, pushing the government to have this. But the timing of this meant that it was pushed through in a very absolute framework, you know, without the sorts of space for justifications, exclusions, the sorts of things that we'd expect to see. So it was more than was necessary to achieve the objectives. What it also did, coming in the time that it did, it hadn't given the common frameworks the time to see whether they could effectively operate. I mean, I think they'd been introduced in 2017. We had the first discussions of those. It was, that potential there was shut down very quickly by the adoption of this legislation. They weren't given the opportunity to live. And so now we're returning to the opportunity to give them the space to manage the market. I think, were we to move away from having this piece of legislation, we'd still need some sort of governance architecture there. I think the role of the Office of the Internal Market could continue to play very usefully a role within the management of the market.
Just to say that when they were before the committee, they didn't really seem to have any real powers at all.
As yet, they don't. So I think, well, as yet, their role is very limited. Their role isn't equivalent to, for example, the Commission's role as an independent actor, sort of arbitrating across the member states. So, you know, it could be an enhanced role for the Office of the Internal Market, giving them a different set of functions around the management of the market than they have at present. I mean, as we have at the moment, that institution is one, the organisation is one that has quite limited powers. It has got, at the moment, it appears like the trust and the confidence of the various parties, but within quite limited terms of what they're able to do, but perhaps looking for a future role for them to offer more of a management role within the market.
I don't know what to add to that.
I think there is an opportunity there. I think the main challenge we've seen with the exclusion process is it's frankly not really a process. There's not a set out form, a timeline to allow for certainty, and it creates uncertainty and confusion both within the legislative space but also for businesses. I agree with Joe that I think there's a real space for an impartial actor. I'm very uncomfortable with the idea that the Secretary of State is making can veto your use of power. The veto power of the UK government in this instance feels very problematic to me. I don't know if there's much prospect for kind of a full repeal and going back to the drawing board. And how would that process take place? Would that be an intergovernmental process? That seems like a very long and difficult process, which the UK government at this particular political moment might not want to engage in. But I think there are, within the overarching framework of the Act as it stands, there are legislative changes that can be made, including introducing principles of proportionality and subsidiarity. And as Thomas said, putting the burden on proof on the UK government to say, this is an impediment to the internal market. This has real effect on the economy of the UK as a whole, which I think could be really important, because right now it seems that the burden of proof is very much on the devolved governments who are attempting to exercise their legitimate devolved powers. And if they're prevented from doing so, I think there's a real risk that they say, well, we have this idea we want to introduce really ambitious environmental legislation, but it's just going to be knocked back. It's going to be financially costly. It's going to be politically costly. And so therefore we won't do that. And that's where we see regulatory chill come in.
Professor McHarg?
Yes, thanks. I can remember giving evidence to your predecessor committee very early in the Brexit process about management of the UK internal market. And Joe is right that it wasn't just about there wasn't just a concern about internal trade. There was also that concern about facilitating trade deals. And so there was a recognition that the existing devolution legislation minus EU law might well be inadequate, and some sort of internal market legal framework was certainly something that was identified as an option. The process, the Brexit process, without wanting to rehash it, but as you know, that was a very difficult process, and these internal issues perhaps weren't given as much attention as they ideally should have been until fairly late in the process. At which point we got this very rushed kind of out of the blue piece of legislation. In terms of what I would do if I had a blank piece of paper, I think I would agree with Thomas that shifting the burden of proof is important. So I think at the moment, devolved legislation, England-only legislation potentially, is automatically disapplied if the market access principles apply. I would rather see the removal of that automatic disapplication, some sort of process of having to prove that divergent regulation does in fact create problems for the internal market. And I would accompany that with rather than relying on the exclusion process, so kind of all or nothing, either a market sector is subject to market access principles or it is not subject to the market access principles. I would rather see more of a case-by-case balancing approach so that the market access principles are, as a matter of law, balanced against a wider range of public interests, and that balance is subject to a proportionality test. So those would be my two major asks.
Okay, my only other question that wouldn't necessarily require a response from everybody is, I think it's unlikely that political parties thorough to a centralised unitary state in the UK will cede this power back voluntarily. I think that's probably hoping for too much. But one of the issues seems to me to be a political one, whereby a UK government will not want to be overtaken on the outside by Wales or Scotland doing something which is innovative and takes them ahead of the game. They won't want to see that for political reasons, and they'll dampen it. But more crucial is the point that's been made about business. If business were here, the one thing they will always say is they don't like uncertainty. I think it's Professor Horsley made this point. It's a bit like, in my view, the planning system. For years I used to rail against planning officials in my council, because all they would ever do is wait until somebody did a design for a house or a development and then say no. Instead of engaging with them and say, this is the way to get what you want, it would just be, try your best, and then usually we'll say no. That seems to be the space that we're in here. And if that is the space that we're in for businesses or anybody else trying to innovate, then that's where innovation will die and ambition will die, because the uncertainty, including the idea of sunk costs that you take to try and develop something, are not something that's going to be a good prospect for people. So is there any other change over and above the ones which you've already outlined, and only if somebody occurs to somebody, which might, even if we're stuck with this regressive legislation, that might help address that uncertainty for business? Or is it covered by the responses that you've had already?
I think if we can just draw parallels again with systems that we see elsewhere and the EU system, there is a process where legislation that is in development needs to be flagged to an independent body, to the Commission, to review whether or not this is going to be problematic from the market's perspective. And the Commission can decide, during that period, there's a standstill on that legislation proceeding until it's been approved, that we can move forward. And the Commission can choose to say that this is something that should be done on an EU-wide basis. And that whole process is a very transparent process. And those notifications are in the official journal. It's an open process that is then transparent and available to all. And what we don't have built in to this system is anything that does that in an open and transparent way. There may be intergovernmental activity taking place, but again, it's something that could be brought into our system using perhaps the Office of the Internal Market as the repository for those things, as a space for those things to be discussed, and have it at a transparent basis, being able to be open to business interests to have a view of what's potentially coming down the line and how they respond to that. That's just drawing a parallel from something we've had before and operated before, would have operated.
Well, like the Commission, it'd have to be something that wasn't an interested party in the way that we have just now with the UK government. It's got both political and territorial reasons for advantaging one area over another, so it wouldn't work. In the past, we all had a say in the Commission, the Council of Europe and Parliament. Now we don't. It's the UK government and the caprice of the UK government that decides it. Yeah, I'm fine with that.
Yeah. Can we move to questions from Mr Bibby, please? Thanks.
Thanks. You've covered a lot of what I was going to ask about there, but just suppose following up from Mr Brown, businesses definitely do say they want clarity and confidence, and I suppose that there's a challenge for the devolved governments as well as the UK government as well in terms of having that clarity and confidence as to how the processes work. Talked about rodent glue traps earlier, and the obviously that exclusion has now been applied by the UK government. Members have talked about when we're talking about where exclusions apply and don't, about the real effect on the UK economy, about proportionality tests, about burden of proof. In terms of providing that clarity and certainty for businesses and for organisations and for governments, clear and transparent thresholds would seem to be something that could help. I just don't know if you've got any further thoughts on what that could or should look like in practice. I know we're talking about a real effect on the UK economy. What is that real? What is a real effect on UK economy? What is proportionate and what's not, and what should that? I just wanted to get your thoughts, if you had any further thoughts on what that should look like.
start us off. Great. And I think that is something that we've heard, and the OIM's work with businesses has suggested that this is incredibly important, both clarity and confidence. I think the reform of the exclusion process can contribute to that, because if there was a set process and a timeline by which decisions would be known. We saw with the single-use plastics ban that there was a regulatory gap because the exclusion came through quite late, which creates uncertainty. There's no reason that the exclusion process couldn't run in parallel with the legislative process that's happening here. So if there's an introduction of a ban on a product or a restriction on a certain chemical, etc., that exclusion process doesn't need to wait until the legislation has passed or the legislation is fully formulated. The evaluation process could run alongside. So if you had a moment in which an exclusion was requested by a government, triggered a process, either by the OIM, by an intergovernmental body, the Intergovernmental Relations Secretariat, etc., a process of data collection and research and gathering could take place, and that could take place, and there should be an expectation that you, as you're legislating, should know that within 30 days or 60 days or 90 days, that exclusion decision would be made. I think that's really important.
Thank you, that's really helpful. And do you have any thoughts about when we're talking about an exclusion process based on no real effect on the UK economy, what that could mean in terms of monetary value, in terms of an impact?
I'm not sure. I don't think I have a kind of full answer.
I know that's a difficult question for you
yes,
to answer.
I think that might be, those thresholds might need to be agreed or discussed through an intergovernmental process, or agreed if the OIM was to be given more robust powers, and perhaps that's an opportunity to say, well, if this is under a certain threshold, then it doesn't have a real effect.
But I think if we draw comparisons with how things operate within an EU context, the justifications there recognise that a particular measure may have an impact on the economy, but may nonetheless be saved and justified because of public policy reasons. And so the concern is, I mean, if we look at how the OIM operates, it does a decent job of assessing the market impact, the economic impact, but it's explicit. It's only looking at those things. It's not looking at wider policy objectives or what the consequences might be, environmental consequences of a particular action. And so it's being clear about who's assessing what, and then where that is then, all those things are then brought together, that it's not the fact that simply saying there's an impact on the economy means that it cannot be allowed to continue, that it's recognising that things may have an impact on the economy and a negative impact on the economy, but have broader public policy objectives that are given greater value in that particular case. So it's bringing those things together.
Okay, thank you.
May I just want to add a little bit to that. I've already said that my primary win would be to suggest a change of the reversal of the burden of proof. I think that's really key, and again, that's how it operates in other systems. So I think that would be a massive win for devolution, but also a win that would safeguard the integrity of the internal market, because it would provide a framework for the UK government to say yes, you need to pursue an exclusion. But I think what's missing, and Aileen mentioned this at the beginning, we have a very heavy-handed legal framework. Okay, the market access principles are pretty undiluted. But we also have a political space that's perhaps too political. And I think one of the things that could be used to address this is to push towards evidence-based decision-making. So my view would be the burden should be on the UK government to adduce evidence that the ban on the supply of glue traps in Scotland is going to have this massive impact on into UK trade, and if you can provide the data and the evidence, then great, make the Scottish government go through the process of an exclusion. But if there's not that evidence base, then there's your answer. So I think that we need to move into a more evidence-based reasoning process, and I think that would help business. Business could feed into that, and I think the OIM is an obvious repository for that type of case building. It already has powers to provide reports, technical reports on perspective and also past regulatory changes. It's mandated to act even-handedly. Whether it would want these responsibilities is a separate question, but I think it would be, it's an obvious way in which we could perhaps boost the evidence-based reasoning, which I think is essential to making this framework function.
Thanks. Professor McHarg, have you got any further thoughts on that?
Yes, thank you. I mean, you're right to highlight uncertainty in UKIMA, and there are different types of uncertainty that operate, but they are mutually reinforcing, unfortunately. So we have quite a lot of legal uncertainty. As to what the tests in the legislation mean. The line between mutual recognition and non-discrimination, for instance, is not drawn in exactly the same way as it was under EU law. So there's a degree of uncertainty around about that. There's a huge practical uncertainty because this operates through not invalidation of legislation but disapplication. It can often be very difficult to know how that disapplication process might actually affect a particular market. It will depend often on very particular circumstances of particular markets about the balance of local producers versus importers. It might depend on whether regulation is going with the direction of market trends or against market trends, and so on. And then we have political discretion, of course, as I've already talked about. As I say, these things are, it seems to me, mutually reinforcing. For instance, we've had no cases yet testing the meaning of the market access principles, and that is at least, well, there's various reasons for that. Partly because we're still relatively early days, partly because business don't seem to be all that keen on relying on the market access principles. Partly, of course, because as I've already said, we rely so heavily on political exclusion. So I think the kinds of reforms that I talked about would help to reduce all of those levels of uncertainty. Over time, we would get greater clarity about what the rules in the Act mean. We would get more guidance about the operation of the proportionality test, about what is considered a significant impact on trade, for instance. So we're in a situation, where we have lots of uncertainty and we have very few means of addressing those uncertainties. So yeah, I would agree with some of the things that the others have said, but I think a stronger, clearer legal framework that actually encourages people into court occasionally, that's not a bad thing, but also, gives guidance on how the balance between different objectives might be struck would be desirable. Thank you.
Thank you.
Does anyone else want to answer, Mr. Bibby? Thank you very much. And begin, Mr. Harvey.
Thank you, Convener. Good morning to the panel. I've got one question on principle and one more practical question. On the principle, it seems to me that we still have a real concern that major constitutional change requires democratic legitimacy. When this Parliament was created and when it was given the authority over devolved policy areas, the public were asked for consent for that major change to the constitutional framework of Scotland. And they said yes. When the UK proposed to leave the European Union, much as I regret the fact that that question was answered in the way that it was, the public were at least asked the question, and 52% UK-wide, 38% in Scotland said yes. But even at that time, the subsequent constitutional changes that UKIMA represents were not proposed. They were not on the table. Nobody in any part of the UK or Scotland said yes to that major constitutional change, and Scotland's Parliament said no. Whatever changes emerge from the UK government's review, how do we achieve democratic legitimacy, which is currently lacking, for this new constitutional framework, which will continue at some level to constrain the powers that were given to this Parliament by the public?
Harvey, or
Any volunteers?
Sure. I'll go
Courtney,
ahead and
thank
start.
you.
Absolutely. I think we see the challenge of legislation and the ongoing fallout of legislation introduced, internal market legislation act introduced at speed and without the consent of the devolved governments or devolved parliaments. In recent years, we've seen this decline of the sole principle and a kind of hollowing of it. The UK government has made motions or has said that they would reaffirm Sewell, reassess this. We haven't seen a ton of progress to date, but I think this is a real opportunity to say, if we're passing legislation that has consequences for the devolved parliaments, those devolved parliaments should consent to that legislation. That might require significant intergovernmental negotiation and wrangling. I think it's a promising sign that the review of the Internal Market Act was brought forward from its original review date. But that's a real concern, because what happens if you revise the legislation or propose revisions to the legislation and the devolved parliaments continue to say, no, this doesn't work with us, this is inconsistent with devolution. And then do you come to a kind of crisis point in intergovernmental relations? So I don't have any solutions to that, but I think it is something that we absolutely need to bear in mind as this process goes through, is the consent of the devolved parliaments for this broader process, this underpinning, this kind of framework legislation is really, really important. When we look at comparative cases, we've never seen an internal market imposed like this, just kind of overnight, all at once, without the consent. Most internal markets are very iterative. They're challenged, they're tested by case law, and we haven't had that opportunity to really test the internal market here.
And you're emphasising consent of the devolved parliaments rather than governments, which common
devolved.
frameworks rest on governmental agreement.
Yes.
Any other views on this question?
Reinforce that, and given the constitutional significance of this piece of legislation and the reach it has into devolved competence, that absolutely, that. I think, the review of this, the opportunity is there now. One would hope that with a reset, a renewal of intergovernmental relations, that if that could be fully reflected within the process of reviewing and revising this piece of legislation, that there is a more consensual, cooperative approach, but also one that brings in the parliaments appropriately.
Yeah, I would just I would add to that only by reinforcing and saying, look, consent and co-design are absolutely critical in any system of multi-level governance. As Carrie said, take another internal market. Parties may disagree on particular outcomes in particular policy areas, but we have fundamental agreement about the basic structures and principles. States voluntarily join these systems and they can leave them. We have a system where, under its current structure, the UKIMA was imposed. That's very difficult to see as a lasting basis for stability. It's possible it could be amended. That may have some impact on the strength of feeling towards that instrument and that legal framework. But we do live in a constitutional and operate in a constitutional world where this is part of a broader set of relationships between the UK and devolved governments, connecting, as Corey said, with issues of Sewell and those issues. But the common frameworks, on the other hand, do have that consent and they do have that co-design. But as you alluded to correctly, we need to make sure that the parliaments are involved in the scrutiny and input into those processes. And that's something that's still ongoing and, in my view, should be part of the effort to finalise those. That is really key, that we always remain a focus on this here in Scotland as being the locus of political decision-making in devolved areas, the Parliament, not necessarily the government.
Thank you. Not sure if Professor McHarg was looking to come in as well.
Yes, thanks. So yes, obviously I agree that that consent is important, and consent mechanisms will differ depending on the nature of the reforms that are being proposed. If the reforms are purely in the intergovernmental space to try to make the exclusions process work a bit better, for instance, that will need to be agreed. There may be reforms which are implemented using delegated legislative powers under UKIMA, which are subject to a consent mechanism. Other reforms might require primary legislation, and I would hope that the Seoul Convention would be respected in that situation. But I just want to kind of maybe strike a slightly cynical note, which is to say here it's not so much or it's not just consent at the end of the process that matters. It's also the power of initiative. And the danger in this review process, Corey is right that bringing it forward and widening it beyond the what was strictly required by the statute. These are positive things, but there is a risk that the reforms that are proposed will be of a fairly minimal kind. And it's unfortunately, and there's no way around this, it is the UK government that holds the power of initiative here. So you are going to be in a position of devolved governments or devolved parliaments consenting to something that is proposed. If the UK government doesn't want to do something, that will be very, very difficult to change that.
Professor McHarg has moved on to the more practical areas that I was going to follow up on, I think, in terms of the kind of changes that we might actually see politically realistic. I'm clearly going to lean toward the view that we don't need a framework like this. For well over a decade, the Scottish Parliament and the UK Parliament made decisions and legislation on areas that impact on business interests and others, consulting at the same time on issues like charity law, planning law, water quality regulations, just off the top of my head, great many other issues, heard from the same stakeholders, understood the consequences of divergence or making different decisions, and made a political judgment accountable to the electorate about whether those areas of divergence were justified. I'd rather we got back to that way of doing things. But it does seem likely that even if the UK government wants to have a bit more emphasis on common frameworks, UKIMA or something very like it is going to remain in the background with some degree of change. Professor Horsley has talked about shifting the burden of proof, and it seems to me that would be a significant improvement, but I'm not sure that it would deal with the question of uncertainty, either for business interests or for policymakers seeking to innovate, if they still don't actually know what they're ultimately going to be allowed to do. And both in oral evidence and in some of the written evidence, there's been some discussion about the grounds for exclusion. Should there be a specific list, a longer specific list of grounds for exclusion, or something more open-ended? Could you explore the options and the tensions there between, for example, a specific list of policy areas or a specific list of principles, like, for example, if a devolved government is implementing a manifesto commitment, that should be protected. There'd be a democratic argument for that. Or for something more open-ended in terms of the exclusions process and how it works. What are the tensions between those different approaches?
There are a number of different ways in which modifications could be made to UKIMA, and I think, as I say in my evidence, again, I think this is something that the committee should turn its attention to, even if there is a political move towards a common framework, because UKIMA will be in the background. I think we set out in our evidence some ways in which things could be modified. I'll just highlight some examples. I think that perhaps at the outset is to recognise that there is uncertainty is sort of built into an internal market. There is going to be a degree of uncertainty unless and until certain rules are challenged or litigated. I think that is just a fact. If you look at the experience in the EU or the WTO, that's why we have adjudication panels, that's why we have courts. There is a testing, and I think also this is a very new instrument. It's a new model, the UKIMA. We've got, the internal market in the EU has been operating for decades, and it's an incremental approach of building up the substance of what those principles are, what they mean, so business will over time, for example, get a clearer set of ideas about what the limits around non-discrimination, mutual recognition are, etc. But certainly I think opening up the space, so reforming the UKIMA to include space for the possible defence of proportionate non-market interests. I think that is something that should be considered as a very important change. I mean, there are other things that could be done at the stroke of a pen, with or without the consent of the Scottish Parliament. The UK government could remove, in whole or in part, huge areas of devolved policy making or from the scope of application. The problem with that, though, is that a future government or the present government could undo that again without the stroke of a pen. Yeah. So, you are relying ultimately on that issue we've raised. But, you can expand the justifications, you can remove things from the scope, you can introduce new principles. I think these are things that should be encouraged, would help to make the framework more effective. But that only operates, I think, if you make some of those big structural changes. Yeah. You shift the burden of proof and you demand evidence. And I think that is the way in which you can operationalise these issues. But as I said in my evidence, there are things there's a wish list of things which I think, if I were in that position, I would be asking. Again, as we've said, in the knowledge that whatever happens in the political space with the common frameworks, the UKIMA is there, it's a nuclear instrument, and it can be used to allow the government to be a veto player in a system. Without necessarily having evidence of an actual impact on inter-UK trade. I mean, the glue traps I come back to, there wasn't much evidence there. And what do we see now? A new government saying, well, you can have that. But is that the system you want to operate in, where a UK government can say, or one UK government can say, no, you can't do that, but we're not going to give you an evidence base of the impact that it has. And then another government saying you can have it. It feels very discretionary and it feels very antagonistic to devolution, whoever's in charge in the Senedd here or in Northern Ireland, and it does lack that evidence base. So I think those two things need to run together for the system to work more effectively.
No, I mean, there are many aspects of this. If you're going to have a framework like this, you want to be able to cope with times when there's a good or bad relationship between the governments. You want to be able to cope with changes of governments and changes of ideology. You want to be able to cope with an emergency situation. You want to be able to cope with the emergence of new policy areas that test the boundary between devolved and reserved areas. And I find it difficult that a framework is going to be able to withstand all of those pressures and those we can't predict. Any other panellists want to comment on these? The practical question, particularly around, if something like the exclusions list is what's more likely to change, if that's the kind of area we're likely to see willingness to move, how should we implement those kind of changes?
Yeah, just drawing back reference to the system that was in place before, that the EU provisions within the treaty where it provides the free movement right, built in at that within the treaty there as well are specified grounds on which justifications and exclusions can be made. But as that free movement provision was interpreted ever more broadly outside of catching just discriminatory measures, so the court opened up a wider set of grounds that went beyond what was set out in the treaty, and so a general public policy justification was opened up, that the space there for things to be presented and the case to be made why the public policy reason was there. So it's, if we do look to expand, would we be tracking what is in the treaty, the free movement, the exceptions there under the treaty? That in itself is only part of the picture. The mutual recognition principle applied in such a way that it was conditioned by more general set of justifications, public policy justifications. So it's capturing all of that. And as ever, we've only taken parts of what was there before.
Point. Aileen, did you want to come in? Yeah.
No, I'm fine, thanks.
Okay, I was just checking. Corey, yes.
Hi, great. I think I would echo my colleagues, but I guess I do worry that our emphasis on uncertainty it can override some of those principles that uncertainty is inherent in political systems, even in much more functional or much more mature internal markets. There is uncertainty. Both the Danish and South Australian DRSs were delayed, and because they were challenged by industry and the court processes had to take place, they responded and adapted their policies in light of those challenges. But industry also adapts as well. Multinational corporations probably aren't waiting to sit around to see what is done here or even at Westminster on single-use plastics. They're looking to Europe. They're looking to other major economies as well. So I think we can. I would hate for us to get ourselves into a position where we say uncertainty has to be avoided at all costs. Obviously, you don't want businesses put through prolonged periods of uncertainty. But if there is a direction of travel, if there are challenges, if things need to be worked out in policies as they're implemented, that's natural. That there's a process of policy learning, and there's probably advantages for the UK as a whole, for one of the constituent units of the UK to say, well, we've tried this out. We've banned these single-use plastics. We've made these modifications. We've introduced these environmental protections. And here's what we've learned. Here's what you might want to consider in your legislation. So when we think about both the devolved capacities, but also UK-wide capacities, there are real opportunities there.
That's really helpful. Thank you.
Thank you. I'm afraid we do have a second panel, so we have run out of time, but I know Mr Kerr wanted back in. I wonder if the panel would welcome a follow-up later from committee members with further questions. Thank you. Really appreciate that. Thank you all for your time this morning. I'm going to suspend for a 5-minute comfort break before the next panel. Thank you. A warm welcome back to committee this morning. Our second panel this morning is part of our inquiry into our consultation for the UK Government's review of the UK Internal Market Act 2020. I refer to my early statement on sub judice, and I won't repeat what I've said, and I know our second panel have been briefed on that issue too. But remember that the discussion around UK exclusions process, including in relation to the deposit return scheme, is allowed for the purpose of our inquiry, but direct discussion of the active case of Biffa Waste Services Limited against Scottish ministers is to be avoided. We are joined this morning by Johnny Hall, Director of Policy at the National Farmers Union Scotland, and Lloyd Austin, convener of the Link Governance Group, Scottish Environmental Link. If I could start with a couple of questions. We have previously recognised that there are significant challenges in managing the tension that exists in the internal market between open trade and regulatory divergence. What opportunity does the review of UKEMA provide to address these tensions? And if I can maybe go to Mr. Hall first. Thanks.
Thank you very much, Convener. I think very much that from NFU Scotland's point of view in the agricultural industry, and probably speaking on behalf of the wider agri-food sector of Scotland, which is fundamentally important to the Scottish economy, as we all know, I think the review of the UK IMA is very much overdue. No surprise in me probably saying that, and is welcomed. As something of an opening statement from myself, obviously, the UK IMA is clearly there to act as some sort of backstop in order to ensure the free movement of goods and services within the UK single market, and actually probably more practically the GB single market, given the issues around Northern Ireland and the Windsor Framework, etc. But nevertheless, acting as a backstop, it's actually become more of a I'm not quite sure what the analogy is. If backstop is meant to be there as a safeguard, as a safety net, or whatever it might be, it's actually almost driving things in the wrong direction, I might say. And we'll probably get into some of the discussion around that. From our point of view, we always supported the development and implementation of common frameworks. Absolutely behind the principle of common frameworks, building consensus across devolved administrations, and working together with the UK government to ensure that the UK single market, internal market, operated as effectively as possible, so that there's no competitive advantage or disadvantage depending on where you produce food or sell food or whatever it might be, and so on. I think to add on to that, the reasons why that is because clearly, given EU exit, that created a fundamental opportunity in many ways, and notwithstanding our position as an organisation would be to remain within Europe, our view in terms of the benefit of EU exit was, in fact, that you could actually develop devolved policy even further. Particularly, I'm talking about in an agricultural, rural context in particular. Because clearly so much of agricultural practice was governed by not only the Common Agricultural Policy, but also by EU directives, etc. Water Framework Directive, Habitats Directive, Birds Directive, Nitrates Directive, you name it. Lots and lots of regulatory frameworks, if you like, that were applied to the UK as a member state, and which Scotland had a wee bit of wiggle room, but not an awful lot. So about, I would say, ballpark figure, about 90% was a gift from Europe that we just had to implement in many, many ways. But the benefit, if that's the right terminology, of EU exit was to create an opportunity for Scotland to be far more clear in setting its own devolved policy around agricultural support, but also the compliance issues and the regulations around environmental management, animal health and welfare issues, and so on. All those sort of devolved competencies that are part of the devolution settlement. And that was very much welcomed. And clearly, the role of common frameworks was going to be critical in that, because we obviously, along with other farming unions across and other interests across the UK, recognised that we wanted to have devolved policy in the different devolved administrations, but we also didn't want that to interfere or distort trade within the UK. And finding that balance is always going to be important, but finding a balance is usually built on consensus rather than on having an absolute backstop. And that's, I guess, where the UK Internal Market Act put us in terms of those market access principles around non-discrimination, mutual recognition. And I think that put us on the back foot from day one. I certainly remember the consultation from the UK government and then the process of the bill becoming the Act in 2020, etc. And thinking, well, this is okay so long as common frameworks work. But unfortunately, the experience we've had since certainly 21, 22 is that common frameworks haven't worked at all. There's been little or no action in and around common frameworks for various elements of devolved responsibility. And it feels that ultimately the backstop of the UK IMA will rule rather than us being able to develop devolved policy. And I'm no doubt going to get into more issues of practicality as we go through this process. Thanks.
Thank you very much. Mr Rawson.
Thank you, Convener, and thank you for the invitation to give evidence. And the Scottish Environment Link welcomes the UK Government's review, and it's very welcome that this committee is undertaking this inquiry in order to input into that review. Our concern is obviously with the environmental impacts, or rather the impacts on the development and implementation of environmental policy. But in particular, the environmental policy in devolved administrations. One of the key sort of ideas behind devolution was the development of policy appropriate to the local circumstance, local solutions, the local problems, so forth, but equally the opportunity to innovate, to do things differently to elsewhere, to reflect local environmental situations or local agricultural situations, etc. And in that way, the different parts of the UK could then do things in different orders, depending on the local arrangements, or apply different priorities to different environmental aspects, etc. But equally, it generated what we've liked to call a race to the top in terms of environmental standards, so that some administrations would go first in implementing an environmental policy. The carrier bag charge is a classic example of that, where that was implemented in one part of the UK first, and then the others took it on, and learn the lessons from one going first, so to speak. So there is a kind of benefit in different approaches in different areas, and each learning from one another and generating that race to the top. And yet, what we've seen since the UK Internal Market Act is a kind of prevention of that approach, so that environmental policies proposed by devolved administrations are constrained, and as the previous panel were discussing, in some cases we see a chilling effect, so devolved administrations become reluctant to bring forward an environmental proposal because of the potential challenges that will arise with the Internal Market Act process. And we are supportive, as Johnny's described, of the common framework principles and working together. We've got a number of concerns about the way it's worked. But if you rely only on that, then actually what you end up with is, I think, the lowest common denominator. I think you've got to enable in devolved competences, within devolved competences, areas that are devolved, the devolved administrations and the parliaments have to have the ability to do things differently if they want. That's the purpose of devolution as we understood it. I think the examples given by the previous panel in terms of multi-jurisdictional internal markets and the ability for there to be subsidiarity within the different jurisdictions in that market where each individual administration wants to pursue a public policy objective such as environmental protection is the key thing, and therefore that will bring the discussion on, I'm sure later on, onto the exclusion process in the Internal Market Act. I'll probably finish there.
Okay, thank you. Yeah, we heard that phrase lowest common denominator earlier from the panel, as the previous panel. Looking to questions, I can bring in Mrs. Stewart and then Mr. Brown.
Thank you. Mr. Hall, you've touched on, and I asked some questions about this sort of prioritisation of the common frameworks in the last panel, and you may not have heard all of that, but you've already indicated today that you, as an organisation, support the principles of the common framework, and the common framework is integral to the internal market. And you also believe that there should be areas where that should ensure that there is opportunities for support and divergence can take place. But at the same time, you also indicate in some of the information you've given us already today that you believe that overriding the common frameworks could result in environmental, animal welfare standards and food all being potentially problems, and you think that is a major omission from this process. So it would be good to hear that. Obviously, you've raised some concerns in your opening, and I acknowledge that. But how can and how will this whole process progress if there is some redesign of the common frameworks that will be more advantageous to supporting your sector and supporting the industry that you look after?
Very valid question. I think most importantly of all, well, I'll say right now, I'm no constitution expert, but nevertheless, I think from a Scottish agricultural stroke agri-food perspective, the internal market is in fact England, if we're being really honest about it. And it's so fundamentally important to the prosperity of the agri-food sector in Scotland that, you know, so much of what we do produce does actually just head south, and an awful lot of that just is consumed within the M25, to be honest. And whilst other markets are very important, that is our bread and butter.
Yeah.
It's not necessarily the other way around. It's not that Scotland is entirely dependent upon food flows coming north. Of course, we do import as Scotland in many ways, but the value and the importance to the Scottish economy of the UK market, particularly England, is significant. I think on the common frameworks piece, the intention back in 2020 or 2019, 2020, when this was all being discussed, was very clear that there would be consensus, there would be agreement, and that we would have some principles in place around common frameworks that would prevent any of the devolved administrations, including the UK government, from having a veto over all the others. So you would build things on consensus that would respect the need for devolved policy making and differences, but would try to ensure that those differences would not have an undermining effect on the functioning of the internal market. And we're now in a situation in some ways, because common frameworks have almost been set aside in many, many ways, and the backstop is now at the forefront, if I can mix those things up, that we are just starting to see, and it hasn't really manifested itself yet properly, but we're just starting to see those divergences happening across the UK, whereby I think there are potential risks to the interests of Scotland and Scottish agricultural producers.
How detrimental to the interests of Scotland, as you've indicated, would some of these divergences be?
Difficult to predict at this moment in time, whether it's economically, environmentally, socially, or whatever it might be. But I'll throw a particularly controversial issue out there. precision breeding or gene editing, whatever you might want to call it. England, through DEFRA, are advancing that very quickly. And Scotland is not, because the Scottish Government, Scottish Parliament have been quite clear that, if anything, we will keep pace with developments at a European level on such things rather than going out as a devolved administration in that respect. So as things stand, on the near horizon, there's this differential between production in England being able to utilise gene-edited techniques versus producers in Scotland not. And yet, we're still reliant on significant imports of things like grain from England into Scotland in order to underpin things such as whiskey production, distilling, and other things as well. So that immediately says, well, there's a potential there for some sort of competitive disadvantage or advantage. Setting aside whether you believe that gene editing is an appropriate thing to do or not, but because all of a sudden you're creating an uneven playing field, to use that cliche. So things like that, in terms of the development of what happened in England, in terms of that legislation, the plant breeding techniques legislation that came forward, there was no real discussion at a devolved level around that, because there didn't need to be one. So there is no common interest, or there was no common conversation or engagement or consultation around that. That was a unilateral thing that England were able to do, knowing that they had the backstop of the UK IMA that said, actually, those market access principles, if somebody's growing grain in Northumberland, for example, using gene-edited techniques, and they literally send a truckload up the road across the border, and they go up to Simpsons at Harrington to have it malted, or whatever it might be, no distance whatsoever, that was going to be perfectly legitimate.
Okay, thank you. And Mr. Osner, what if there are any of the environmental link issues that are related to what we've just been discussing? Do you see there being any things that you are suggesting could be problematic or within your own sector are concerns? Do you see it as an omission from what you would have as safeguards within your own area?
I think I would make two comments. First of all, on common frameworks in principle, I think common frameworks in principle are good. I think the system whereby governments talk together and agree things is a good thing, but there has to be an agreement to be able to be different if that is what is wished by the respective governments. Our experience of common frameworks to date is that actually there hasn't been much substance to them. They've been processes, they've been frameworks that establish procedures and processes by which policies and substance are discussed. And actually the policy and the substance is not in the framework. The framework is the process, if you see what I mean. And then as stakeholders externally, we don't see what the discussion of substance is. And so the second thing that I think is an issue with the existing way in which common frameworks work is the lack of transparency and stakeholder engagement in those processes. It's a bit of a for governments behind closed doors having an interesting chat, and where they agree, they then publish it. And if they don't agree, nobody knows what has happened or not happened, if you see what I mean. So that's an external stakeholders' perspective of common frameworks, that there's nothing inherently wrong with the desire to have agreements and equally to agree to differ if you wish. I think that's an important aspect. And in that way, I think that's why it's different to the Internal Market Act, because that agreement to differ, if you wish, relies on the process of having an exclusion. And therefore an exclusion which is effectively in the gift of only one of the four parties that make up the Internal Market Act. And it's that impact on the issues that, I mean, the DRS scheme is obviously a very big controversial and significant environmental policy that was affected by that. But if this had been in place at the time when the carrier bag charge was introduced, that would have been subject to the same discussion, and yet it wasn't, because when that was first introduced, we were under the EU single market rules, and that's an example of where the subsidiarity provisions in the internal market are actually tighter than the previous EU single market provisions, and that's the key to the environmental concern. The environment is one of the public policy objectives which we would view there should be greater flexibility about in the form of the way in which subsidiarity was applied in the European situation, or indeed, as one of the previous witnesses talked about, in Australia.
Okay.
Could I just add very quickly to what Lloyd just said there about the common frameworks, and that it has very much felt that it was about four governments, and Mr. Harvey's point in the last panel about the fact that democratic process seems to be overlooked, that not even the devolved parliaments, but then the point that both Lloyd and I, I'm sure, would make is that what about the stakeholder interest in this as well? That we ultimately have an interest, very much an interest in these things, but we would be pretty much excluded from that common frameworks approach. So I think that if we're going to reignite common frameworks and try and improve how they work, if that's one of the outcomes of this review, then some of that involvement, how you actually engage not only with governments and parliaments, but actually stakeholders as well, is going to be quite critical.
Thank you.
Mr. Brown?
Yes, a question first of all for Mr. Hall, and then one for both panellists, if I could. You mentioned, or Mr. Austin just mentioned, I think you're saying the limited examples of where people have chosen to do things differently. I wonder whether that's the case, that where that has happened, DRS or blue traps have been slapped down and imperiously told you're not doing it anyway, so why bother innovating or trying to do something different in future? But on the example of the gene editing that was mentioned by Mr. Hall, you quite rightly pointed out the asymmetry of it, where the UK government can just do it for England. They don't have to answer to anybody. Everyone else has got to answer to the UK government. Had it been the other way around, I've got no doubt that Scotland, if it's unilaterally chosen to go for gene editing, England didn't want to do it, it wouldn't have happened. That's just the way I think things go. But you made a comment when you were doing your opening statement to say the way it was designed, the way the system was designed, was to provide no competitive advantage or disadvantage. And I'm just wondering, if that is the case, it's not really a market at all, is it? I mean, because it's like going to a market where everyone's selling the same goods for the same price. Surely a market, by definition, has competition, more competitive, less competitive elements to it. Otherwise, it's not really a market.
I can see the point you're making, but I would argue that in terms of making a single market work effectively, and when you go back to where we were under Europe or under EU as part of a member state, the single market, free movement of goods and services was one of the four main single market aspects. And that free movement essentially meant that the flow of goods and services is one thing. The cost differentials were relatively minimal in many, many ways, because you couldn't have such diverging policy in different parts of the EU, given that you were governed by a common agricultural policy plus other environmental legislation. So things like Water Framework Directive, for example. Water Framework Directive applies across to all of Europe. Scotland implemented it in its own way through things like the Water Environment and Water Services Act and all the things that then followed in terms of regulations and so on. That implemented a piece of environmental legislation that upheld standards more than anything else and led to improvement and will continue to lead to improvement in things like water quality and other things around the water environment. That, though, however, did not put any, in my opinion, didn't put any major disadvantage or advantage in terms of Scottish agricultural producers. because the way in which it was done on a common framework approach, essentially, through was that you had that devolved capacity to implement things to a certain degree, but without actually breaking the tolerances of what everybody had to do, the minimum standard piece, if that makes sense. What I'm concerned about with other things now coming forward is that you get such disparity within the UK around things like agricultural support and other things in terms of regulatory requirements, that will put a financial pressure on different businesses in different parts of the UK. Therefore, you're not operating at the same competitive level. And you could argue that that's a good thing, that's a bad thing. I would say that the potential risks for Scotland are significant. Because I go back to that comment I made earlier, England is the single market. So if you're producing in England, you're selling in England by and large. If you're producing in Scotland, a lot of what we produce goes into England. And if that's a different level of regulatory requirement or different levels of support, whatever it might be, then we've got to have a keen eye on how that actually works in practice. And if it is a disadvantage to Scottish producers or the agri-food sector, which is so important to the interests of the Scottish economy, then I think we need to be very clear about that and what does that actually mean. And if it's counterproductive to us, then the single market is not working as it should in terms of being a fair and transparent system.
Thanks for that. And I think it does raise a question of why people in this Parliament would forswear the opportunity to legislate or to have others legislate on their behalf in this area. I'm conscious of the number of things in your written statement, Mr Hall, which coincide with the previous panellist. For example, it's a clear view of NFU Scotland that the principles embedded in the UK Internal Market Act pose a significant threat to the development of common frameworks and to devolved policy, and also that it appears to limit the devolved administration's ability to act if any standards were lowered and give the UK government a final say in areas of devolved policy. And given that, my question to both the panellists is, we were told in 2014 that we were going to be the most powerful devolved parliament in the world, and also that the Sewell Convention was going to be enshrined in law. Within a couple of years, the UK government said that the Sewell Convention was merely a self-denying ordinance. They could choose whether to use it or not. They could choose whether to use it or not. Given the way it's changed, and given the way that with UKIMA coming in, it's kind of reverse engineered, as a term I've used, devolution, do you think this current exercise we're involved in, and given the fact the current UK government does not want to repeal it, is likely to affect the changes that you'd like to see? Or do you think, given the massive changes in the devolved nature of this Parliament, that something bigger, I mean, they had the Smith Commission back in 2015, I have my own view that the public should be involved in deciding the powers of the Parliament, but do you think there should be something bigger, wider than just a very limited review of UKIMA to address the concerns that you have? I'll maybe come to Mr Austin first and then Mr Hall.
Well, I think speaking on behalf of Scottish Environment Link, I will just limit my comments to environmental matters. And I do think that, in relation to environmental matters, UKIMA has had both significant has created significant problems in implementing environmental legislation and environmental policy, and it has had that chilling effect on the development of environmental policy. We very much think that there are benefits from devolved administrations innovating and seeking to go first, or seeking to go further than other areas, or indeed legislating and developing policies for environmental situations that are unique to their country. I mean, Scotland has a significant amount of greater amount of marine environment and islands and coasts than the other parts of the UK, and so things like the Marine Act are in Scotland, the Scottish marine legislation is designed for a particular Scottish situation, and I think so for instance we have in that Marine Act provisions for regional marine planning, which is very important for areas like the Moray Firth or Shetland, which have very different issues to address. And so that kind of thing is different to other parts of the UK. And that was one of the ideas behind devolution. And yet this Internal Market Act has now put an additional constraint on the exercise of devolved competences. And I've talked about carrier bags, talked about DRS. We've had the situations where the process of getting exclusions for very small things like the single-use plastics and the glue traps have been quite, I think, over-onerous on the devolved administrations in order to get them through and be able to apply that policy. One of the areas that I find very interesting is, it was mentioned in passing by the earlier panel, and that is the sale of horticultural peat. Protection of peatlands is very important, both because of the habitat and because of the impact in terms of emissions, the emissions that come from damaged peatland and the sequestration that can happen from unhealthy peatlands. And all 4 governments across the UK have a policy of seeking to move towards eliminating the use of peat in horticultural practice, and that's very welcome. But none of them have actually been able to legislate for it because they're all caught up in this Common Frameworks and/or Internal Market Act, and nobody wants to go first to be caught out by those processes. So we have 4 governments of different political persuasions, all with a very good policy and a very good intent. None of them have been able to actually deliver that policy or good intent because of the procedures. And that just seems to me to be absurd.
Mr. Hall?
Yeah, I would agree with Lloyd's comments there entirely. He touched on peatland in one respect. I would touch on peatland in the fact, looking at Scotland, we have something like 60% of the UK's peatlands here, and things like peatland protection and how we manage and restore peatland is significant in things like our ambitions around tackling climate change, etc. And therefore, being able to legislate in that way to create policy and incentive, both regulation and incentive rather, in order to safeguard the interests of things like peatland, but also you could extend that into things like woodland creation, where an awful lot of that happens here in Scotland vis-a-vis the rest of the UK. To have that within the gift of Scottish ministers, backed by the Scottish Parliament and the support of Scottish stakeholders, I think is significantly important. So again, it goes back to that thing about, I think, Lloyd, you've been using the expression, the UK Internal Market Act chilling the innovation in terms of policy and almost holding devolved administrations back from pursuing what would probably be the very sensible policy and supported by a swathe of interests that say this is the right thing to do within Scotland.
Thanks.
Harvey?
Thank you very much, and good morning to the panel. I was going to quote from the NFU written evidence, but it is a question to both. It seems to me that right up in paragraph 2, you've hit on the nub of the tension here. NFU stresses the need for agricultural support policies to diverge where necessary to reflect different needs and objectives. However, free movement of goods and services and regulation must be aligned so there's no competitive advantage or disadvantage. And there will be people who might emphasize one or other of those objectives, but there is a tension between them. It seems to me there's always going to be a tension between them, and the principle we should be aiming for is not to be absolute about either, but to understand that tension. As you said earlier, to hear from the stakeholders who are affected by whatever divergence may emerge and whatever consequences might arise, and for a clear-eyed decision to be made in a democratically accountable manner about how to manage that tension. And within devolved policy areas, that the default should be that decision is made in the devolved administration or jurisdiction. So I wonder if you would agree, first of all, that tension will always continue to emerge in existing issues we know about and new ones we haven't encountered yet. but also whether there's an additional, as well as those two priorities, those two objectives, there's an additional one. And I think you've both touched on it with different language. Lloyd Austin used the phrase race to the top. And I think Johnny Hall used a phrase that was more like protecting standards or is something of that nature. If, for example, a trade agreement in the future opened the Scottish and UK market to products which undercut your members in terms of environmental protection, animal welfare, a whole host of other areas which we might anticipate, I think your members would be deeply concerned, at least those whose principal market is domestic rather than for international export. So that direction of travel on the regulatory landscape is an additional objective that we need to have in mind beyond just divergence for innovation's sake or for meeting local needs or protection of the market itself. And I wonder if you could both reflect on those issues.
Could I just come in on that latter point? And I think it's a very important latter point in that essentially the integrity, and I'll use that word quite deliberately, the integrity of agricultural produce in Scotland and our agri-food production is fundamentally important to the success of the agri-food sector in Scotland. We are not a significantly huge agricultural economy based on commodity, so it's stack it high, sell it low. We have to have standards that uphold that integrity, whether those standards are underpinned by regulation, or indeed they're driven by the demands of the supply chain, wherever it might be, in terms of whatever the carbon footprint might be, the impact on nature, how we produce things, animal health and welfare standards. They are fundamental to the future success of Scottish agriculture and the food and drink sector. So that integrity piece is really, really important. And I guess that's the sort of flip side, or the potential flip side of what Lloyd was saying earlier on about we want a race to the top. So we differentiate ourselves in many ways rather than a race to the bottom. Mm-hmm. And if we get into that situation through free trade agreements and imports are being sucked in from elsewhere of a different standard, they might be perfectly safe in terms of consumer health and all that sort of thing.
Maybe.
But in terms of the standards of production behind them, that's a different matter.
Yeah.
So things like that remain important, and not just in a UK trading with others situation. It's important in a UK market context as well. The tension piece, I think, that you referred to as well, Mr. Harvey, I think is absolutely true. You'll always have tensions because you've always going to have differences of opinion. Mm-hmm. Lloyd and I differ on many things, but at the end of the day...
Constructively, I hope.
Absolutely. At the end of the day, we usually end up at a point that works for the viability of agricultural businesses, farmers and crofters, but also then delivers for the outcomes in terms of the environment. Now, there's always going to be some tensions in and around that discussion, and maybe some things don't go far enough. But at least at this level, we iron those out and think, how do we get to the end point where we all get the outcomes we want? Now, it feels to me a bit like the UK Internal Market Act actually almost disregards that. Mm-hmm. Almost disregards that. And I'm sort of taking it away from the likes of Lloyd and myself, but putting it at 4 devolved administrations who are pretty much seeking the same outcomes around high quality food production in our case and other things like that, but delivering on climate obligations and nature ambitions and all the rest of it. But we're going to do it in different ways because we are different. The UK is pretty different. You know, what happens in East Anglia is pretty different from Argyll. So you have to have that difference in policy approach, but at the same time respect that we're probably want to try and land in the same place. And therefore, you will get tensions along the way. It's how you overcome those tensions where I think is clear. And I think the market access principles of the UK IMA kind of, I'll use this phrase, ride roughshod over the approach to resolving tensions, which I would have thought would be better done through a properly functioning common framework approach. And that's always been our argument around this.
Thank you. Lloyd Austin, want to add on? this?
Yeah, thank you. I agree with a lot of what Johnny's just said. I think the issue is that, you know, whether in devolved competencies, whether that be environment or agriculture, planning, building standards, all of the wide range of things that are devolved competencies, the devolved administration has the opportunities to make and implement policy and legislation and so on. And in so doing, they take the views of their stakeholders. And let's say take agriculture and agriculture's impact on the environment and vice versa. Johnny and I have sat together in lots of forums where we've disagreed and put our prospective views to the Scottish Government and the Scottish Parliament. And it's for the Government and the Parliament to decide where the balance might lie and where the appropriate place is. And yet that conversation with the various stakeholders is potentially, I can't remember what you just said, but overwhelmed in a sense, trumped by the Internal Market Act if the outcome that the government, Scottish Parliament and the respective stakeholders has agreed on isn't approved for an exclusion. Does that make sense? And so therefore that would be, if what those Scottish Government and stakeholders had developed as a proposal for Scotland in a devolved competency was something that did need an exclusion, that would be better agreed as a different way forward for Scotland within a common framework process. But I would add a properly functioning common framework process, not the one that we've got at the moment, if that makes sense. Yeah. And therefore, I think from the environmental point of view, what we've said, there are lots of arguments that we've heard before from the previous panel and from Mr. Brown about doing more significant changes to the UK Internal Market Act. And, you know, if for political reasons or for other legal reasons or whatever those things happen, that's not for us to say whether that's a good thing or a bad thing. But in terms of the environment, what our report and our which we've submitted as our evidence to this committee has recommended is as a sort of keyhole surgery approach to the exclusions process, so that the exclusions process allows flexibility for devolved administrations in those areas of regulation for the public policy objectives that are in the public interest. And we view that as parallel, or similar to the EU subsidiarity principle. And, you know, in operating the single market in the EU, there's a whole load of case law from the courts about how subsidiarity and how the public interest in different regulatory systems can be balanced against the perfectly reasonable approach of free movement of goods and services in a unitary market. And you're right, there is tension between those two things and there have to be choices made, but we think that there has to be, that the Internal Market Act, in a sense, predetermines where that choice is and gives the predetermination to one of the four parties rather than to an independent body or
to a deregulatory pressure as well.
Yeah, and because of the pressure for kind of the lowest common denominator, that the lowest common denominator rather than the race to the top leads to it being a deregulatory pressure.
Thanks both very much. I would just maybe ask for a trigger warning on the word trumped in future.
Can I bring in Mr. Kerr? Right, thanks.
Yeah, I mean, just as a matter of fact, the UK Internal Market Act does apply to the whole of the United Kingdom, not just Great Britain, as was suggested earlier. I am interested in the NFUS's evidence, obviously written evidence. I'd like to focus on that a little bit and some of the words that you've used this morning, Johnny Hall. In your evidence, you talk about the threat, Keith Brown referenced a direct quote from your evidence. Reading the whole thing, is it the position of NFUS that you would like to repeal the UK Internal Market Act? And what would be the likely effects of that?
Well, I think it's clear from the review that's being undertaken by the UK government now of the Internal Market Act, it's not about repealing it. They've made that very clear. This is about reviewing it and reviewing different parts of it. I don't think it will be repealed. Our position is not, we're not calling for it to be
You're not?
repealed. No. We are glad that, as I said earlier on, we are pleased that this review is taking place. But it needs to be reviewed and amended, but not necessarily repealed. Sorry. So that's our position there.
So can you drill down a bit on that and be very specific, adding to your written evidence? If you don't want the Act repealed, or you accept it won't be repealed.
Except it won't be repealed at this time.
But is the position of the NFUS
The
that
position
you would like it to be repealed, though? And you're accepting it won't be, and I think that's correct. But I'm trying to understand the undercurrent of the evidence.
The position of NFUS on this is that the Act is in place, it is being reviewed, and we view the review as being an opportunity to outline our concerns again about the Internal Market Act and its market access principles, but equally to move that debate and discussion on as to how best we can make sure that the common frameworks concept works far more effectively for all interests.
So an amended UKIMA, that is your proposition?
Almost certainly, yeah. Depending on the outcome of the review, of course.
Well, give me your views rather than dependent on the outcome of the review. What is NFUS's proposition in respect to the amendments, specific amendments you'd like to see?
I'm not sure I can answer that just yet because we still haven't concluded our submission to the review, which is we've got until April or whatever to do that. So I'm not sure I can answer that at this stage. But we will definitely be questioning.
So you've got in mind definite
Got in
amendments?
mind, yeah, but I've still got to go through a process with my board to ratify that position, etc., to ensure that as an organisation we're comfortable with what we will be seeking as an outcome from the review and what our evidence will say in terms of our submission to the review.
So we can't get into the details?
Not at this moment in time.
No.
We've only, the consultation's only been open for 3 weeks, is it?
Yeah.
Something of that order. We've got 8 weeks in total. I haven't had an opportunity yet to talk through my board.
Can you talk about specific areas without getting into the specifics of the specific areas? Can you mention the areas that you're thinking NFUS?
Well, we still have concerns about those market access principles in terms of non-discrimination, mutual recognition, because in a sense that has the capacity to ignore different regulatory frameworks in different parts of the UK, because essentially something produced to a different standard in one part of the UK can legitimately be bought, sold, used in another part of the UK.
Right.
And therefore, if we have diverging policy around some of the issues I've touched upon, and there are potentially more in the pipeline, if we get that divergence going too far, does that put Scottish farmers and growers and the agri-food sector at a disadvantage? It's a question, and at the moment there is reason to believe that some of those issues could cause Scottish producers to be disadvantaged in the UK internal market because of advantages afforded to growers and producers in other parts. So that might add costs of production to Scottish producers that they cannot recover from the marketplace.
So you're talking about divergence in Scotland that adds cost to the production?
Well, it might be divergence in the UK that adds cost to production because it might reduce the cost of production in another part of the UK. So it might create a competitive advantage for somebody in England, for example. But not necessarily, it might not be anything that the Scottish Government or the Scottish Parliament does, but if it's something that changes the playing field.
Yeah.
So that
but it can happen in any part of the United Kingdom.
Could happen both ways. It might be that the Scottish Government implements policy here in Scotland that actually affords Scottish producers an advantage.
Which you'd be in favour of?
Of course. But I mean,
Right, so we can't have one without the other, though.
Exactly, and I think that's where we have to walk a very fine line between wanting a very clear, level playing field in many, many ways, but also respecting the fact that we want a devolved approach to a policy.
So which would might
But that's where-
necessitate
but that's
involve
where-
divergence.
Yes, you're going to have divergence, but that's where the whole concept and principle of common frameworks comes in, that respects and reflects on divergence,
Right.
but says that that divergence is acceptable and tolerable because it is not creating such a distortion as to have an impact on the operation of the internal market.
But
And
even within
and that's that consensus piece.
But even within the unamended UKIMA, we already have devolved policy making for agriculture, as I know that you will know.
We
So
have
why-
devolved, but does the operation of the UK Internal Market Act respect that
Well,
Dev-
let me ask
devolved.
you,
differentiated approach?
we're a long way down the line on all kinds of devolved aspects of agricultural policy post Brexit, and within the time span of the Act, have you had experiences in discussing policy implementation in Scotland where consideration of UKIMA has presented an obstacle?
Internally we have, not with Scottish Government though,
Internally,
in terms of NFU Scotland, and conversations with our colleagues in other farming unions across the United Kingdom.
can you say a bit more about that? Help us understand
I'd
the
rather
issues?
not, because they are discussions that are held in terms of what various other unions think. I can tell you right now that some of our colleagues in NFU in England are sensitive about the fact that we continue to have significant direct support payments in Scotland
Yeah.
vis-à-vis what's happening in England.
So within the NFU, this is an issue that's been raised, that you have an unfair advantage, as it were, in the minds of...
I don't think it's been raised as an unfair advantage. I think it's been raised as a divergence, and therefore what is the justification for that divergence? And those are the conversations we're having. There's a total agreement.
That divergence is under the current
There's a total
UKIMA.
But there's a total agreement that because of devolved capacity, there should be different approaches to agricultural policy
Yeah.
in different parts of the United
Yes.
Kingdom.
It's
And
devolved.
that is completely understood.
But,
how-
within UKIMA, we currently have this divergence, yes?
We have that, yeah.
So there's been no legal
Not yet.
challenge?
Not
Or
yet.
are you expecting something?
No.
Well, there's not going to be a legal challenge then. So some of the things that are in your written evidence and in your verbal evidence, your oral evidence this morning, talk about things that haven't happened at all.
Yes, but they are potentially going to happen.
Why do you say that, though? If they haven't happened...
Because I think that if we have significant divergence in certain regulatory areas and indeed in the way in which we support farmers and crofters across the United Kingdom,
Yeah.
then if we create an imbalance, the market access principles of the UK Internal Market Act will effectively mean that they are irrelevant because there will be no way in order to counter any of those things, because something produced to one standard in one part of the UK can
Yeah.
then be sold in another part.
But we're all agreed that agricultural policy should be devolved.
Yes?
Your argument leads in a different direction. It
No.
suggests that there should
How?
be a...
How does it?
Because you're raising the concern that different
I
regulatory...
don't think I've ever said it shouldn't be devolved. It absolutely should be
Well,
devolved, but you want it to
Well, how do you
devolve.
mitigate the divergence then? You can't mitigate the divergence.
You
It's built
do it
into the
through
policy.
common frameworks called consensus.
Right. Fine, that's fair enough. But the evidence of the first 5 years of the operation of UKIMA is that none of the things...
I think that's because of the regulatory framework in which UK agriculture and indeed the environment operate is still very much a cut and paste from where we were from Europe. We haven't actually extracted ourselves, particularly yet, from what we moved across into UK and Scots law. So I don't think we've had that regulatory divergence to any significant degree yet.
Sufficiently
Not
divergent that
in
your
the
members the NFU members in England have privately raised concerns about the disparities.
Yeah, and we've raised concerns about what's happening down there in
Yeah.
terms of what does that mean? What does that mean for the advantage or competitive advantage or disadvantage for farmers in England over Scottish
Which
producers?
I guess addresses the concern that Keith Brown raised. I mean, what is a market, I suppose? I mean, we have agreed and accepted that, I think we all agree that agricultural policy has devolved, therefore there's going to be different setups, different regimes, different farm payment schemes. That comes with devolution. I would just, I just make the point again that none of the things that are in your written evidence, your oral evidence, are things that would appear to have actually happened, because it's all about potential. I mean, your conclusion paragraph 11 says, NFUS Scotland remains concerned that the UK UKIMA 2020 could potentially override.
There's nothing wrong with making a statement about what you believe might be an implication.
And that's fair enough.
Thank you very much. Are there any further questions from members? Mr Brown? Yep.
Just to come in at that last point, and I know this is difficult, and I understand as well that you do not want to talk up or give more oxygen, if you like, to a potential challenge. Maybe I'm getting that wrong, but that's my impression. But does it not seem at least hypothetically possible that in this so-called internal market, one area might object to what they see as being greater support, government support in one area to another? So it is a viable concern that the current support for Scottish farmers could be undermined in that basis, or indeed for any part of the UK if they're in the same situation.
This is a significant concern for myself, for our organisation. Nobody's mentioned something called the Subsidy Control Act. The Subsidy Control Act also exists alongside the UK Internal Market Act. And the way in which Scottish farmers and crofters are supported today is now significantly different from how, certainly in England, they're being supported and the direction of travel there. So there is a risk that English farmers could easily object or raise a concern about that. However, the landscape of UK agriculture, and particularly in Scotland, is such that actually without those direct support payments, we would not have farming and crofting in much of parts of Scotland. And that would bring catastrophic impacts for many rural communities, rural economies, as well as the viability of the agri-food sector in Scotland. The agri-food sector in Scotland is far more important to Scotland than it is to the UK, if that makes sense. In relative terms, it's far more important to our economic growth and prosperity. Now, as we move forward with agricultural policy in Scotland, working with Scottish Government and indeed our colleagues of environmental interest, putting more conditions on those payments justifies those payments, because they're then going to deliver an outcome that isn't just about underpinning agricultural production, as the Agricultural and Rural Communities Scotland Act 2024 says. It's about agricultural production, food production, alongside delivering on climate, biodiversity and rural communities. And that's the direction of travel we must go in.
Thanks.
Okay, any further questions? Can I thank you both for your attendance this morning. If I could ask just one question. So I don't have a lot of experience in this area, but I do remember when the EU pillar funding came for hill farmers in Scotland. It was delivered to the UK, but despite the fact it came for hill farmers in Scotland, it was distributed across the UK. Given where we are at the moment, given the localised issues affecting farmers in different parts of the UK, do you think that the market access principles are sort of limiting animal welfare and diversity and innovation in those areas?
Well, there's a lot in there. I could give you a real potted history of the allocation of funding across the UK, going all the way back to a certain Owen Paterson, who was Secretary of State at DEFRA at the time, back in 2013-14, all the way through to the Labour Party government's budget of October 2024, whereby actually that was severed. Basically, agricultural funding and fisheries funding was put into the block grant and is now part of the block grant. It's not a ring-fenced pot which is then allocated in different ways across the UK. So that history, if you like, of what happened, what didn't happen is now, I would argue, irrelevant, because there is no longer a UK agricultural budget which is then allocated to England, Scotland, Wales and Northern Ireland. It's all part of the respective block grants. In terms of driving innovation in things like animal health and welfare and environment, I think it's one of the drivers for innovation, the race to the top, if I can use that expression, Lloyd, would be that the fact that we have that devolved capacity to do these things. And as I say, I think one of the most important things that the agricultural and food sectors of Scotland can do is set the highest possible standards, because it's about integrity of product. We don't produce a lot, but we do it at a very high standard. And it's that high quality piece that I think is absolutely paramount to the future prosperity of Scottish agriculture. And it's about the quality, the provenance, and the story behind that that's evidenced by standards and regulation, or backed up by regulation. So things like animal health and welfare are paramount. We lose that at our peril.
Thank you. Mr. Austin?
I think I'll just repeat in terms of environmental policy making, and I would put agriculture within the frame ambit of wider environment, because agriculture has that impact on the environment, and because farmers and crofters are essential in delivering land use and land management, have an impact on biodiversity and emissions related to climate and so on. In relation to environmental policy making, I think those land use policies and environmental policy are devolved, and we have seen benefit in different approaches being taken in different countries within the UK. Benefit by going first and innovating, benefit by learning from what others have done and then following suit. Competition between, in a sense, the different countries, and generating that race to the top. And the application of the UK Internal Market Act has restricted those benefits. And the proposals we make in our report for what we described as kind of keyhole surgery to that exclusion process could, in our view, improve the situation without any more significant repeal or changes to the Act. And it's actually one that UK ministers could do by secondary legislation under a provision that's already in the Act, and we've set out how that can be done. So in relation to sort of environmental objectives, we think that the review should, at the very least, support that kind of that significant change to the exclusion process. Now, there may or may not be arguments from a political point of view, or from a legal point of view, or from other points of view, for more significant reform, and we would assess those if they were proposed, but what we would specifically want is that specific change to the exclusion process.
Okay, thank you very much. I guess my thoughts on this are that, if I'm allowed to say them, is that things like the environment and food standards and welfare are political decisions. And if the market overdrives everything that's a political decision about these things, then that's an additional change into what happens. But I thank you both for your attendance at committee this morning. And I close the committee to 9. If I could just say to members, I should have said earlier on at the briefing, We have a SPICE briefing on Wednesday morning, which Alexander has agreed to chair. I'm not sure if I'm going to be able to make it, but it is on the global geopolitical impact of Russia's invasion on Ukraine. And I thought that would be of interest to the members of the committee. So thank you everyone for the attendance this morning.